My name is Dan McIlroy and I'm a member of the Sedona City Council. Well, I was elected on, March 9th. We were seated, I think, on May 25th. It's been challenging, it's been fun, and it's been intensive in the sense of preparations, research, but I've enjoyed the process. Well, I'm retired from Phoenix. I was a prosecutor with Maricopa County Attorney for 27 years. I've never been so busy since I retired. As I understand it, ADOT was requested by the city of Sedona a couple of years ago to do a pedestrian traffic safety study of nighttime activities on 89A. And they came back with their recommendations, and what was interesting is the continuous roadway lighting was way down the list. Lowered the speed limit, installed crosswalks, a traffic light at Dante, medians, and then continuous roadway lighting way at the bottom. But they jumped on the lighting because they got federal funding for $2 million as a safety issue, and that's what they've been pushing. It doesn't contribute significantly. It's like 4% out of 100 for nighttime pedestrian traffic safety. All lawyers who pass the Arizona bar take a case or take a course called torts. And in the tort curriculum, it teaches you about liability, negligence, burden of proof, things like that. And in order for the DOT to be held pecuniarily liable for an accident on 89A daytime or nighttime, you would have to show that the Department of Transportation breached a standard of care. There are so many factors involved in an auto accident on a highway. You've got the road conditions, the lighting conditions, whether the road is dry or wet, whether there are chuck holes, whether there's a curve, whether the speed limit is set at the wrong speed. And then you have the condition of the driver or drivers. You have the action of the pedestrian. Was the pedestrian impaired or was the pedestrian not impaired? Did the pedestrian step off the curb without looking? Did the driver go too fast? Was he impaired? There's so many factors. Attorneys always go to pull everybody in, the drivers, the state, the city. They're looking for accountability in the deep pocket. That's a legal term. And obviously you can sue anybody for anything if you have the money to do it. So if you had an accident on 89A, you'd want to bring in the city, bring in the state, and they have to fight their way out because they have the resources to pay your claim. But of course drivers have insurance, hopefully, and even pedestrians may have some kind of insurance. So there's a lot of other factors involved apart from just going after the DOT. We study the accidents in Sedona, daytime, nighttime. The daytime accidents far outnumber the nighttime accidents. Almost 10 to 1 are daytime versus nighttime. And I just grabbed that number because that's not too far off. Again, for a plaintiff to succeed in a civil tortious action for damages, the DOT has to be proven to have been negligent in something that they were aware of, and they could say, well, we were aware that the conditions are dark, but again, when the policeman investigates, he's got to determine how much lighting had a factor. It could be impairment, it could be speed, it could be violating traffic laws of all sorts, it could be the pedestrian who doesn't look both ways. A lot of things come into play, and DOT is like a passive player. They're just there, and unless it can be shown that they violated a standard of care by not maintaining the highway or other things, they probably will not be held liable. The Federal Highway Administration has funds for traffic safety, and if the DOT can hang its hat on nighttime lighting as a safety issue, they can get the $2 million for the 96 continuous streetlights. Even though it's a low percentage of contribution to safety, they can get funding for their lights where they probably can't, for lowering the speed limit, crosswalks, medians, or a traffic light. So it may be an economic decision. I've heard that the federal money has an expiration date, and if you don't move within that time frame, it goes away. So they have pressures on them or the money will disappear. So they've given us some pretty short deadlines. August 15th to start negotiating, and January 15, 2011 to make our decision. And it could be based upon the money going away. But again, continuous streetlights were only about 4%. I think for the DOT to claim that they have to force our city to accept 96 continuous streetlights as a safety issue is a non-issue. They have not been able to show statistically in all the studies of this country that people have quoted where streetlights have contributed anything to nighttime traffic safety. Some cities have taken them down or turned them off because they don't have a contribution. So for them to force us either to take the lights or to take back the road, I think is arbitrary and capricious and an abuse of their authority and power. And they really should let us make a decision for ourselves and not being forced by their belief in spending $2 million of federal money.